Good morning, everyone. I'm just going to give it a minute for everyone to filter in, and then we will get started with our workshop today. Okay, so we'll go ahead and get started. Good morning, and thank you for joining us today for Privacy at the Intersections of Title IX and Criminal Cases. My name is Charlotte Hoff, and I am the Communications and Training Coordinator here at MOVA. I'm just going to go over some logistics before passing it over to our presenters this morning. This is a Zoom webinar, so you cannot be seen or heard as audience members, but you can see the presenters, ASL interpreter, and presentation. If you have questions during the presentation, please use the chat function to ask them. As I mentioned, we do have ASL interpretation as well as captioning available during today's workshop. To see the closed captions, go to the bottom of the screen and click on the up arrow next to closed captioning and choose Show Subtitle. If you're having trouble seeing the ASL interpreters, closed captions, or any other tech issues today, please use the chat function to message either myself or my colleague Brenna Chase, and we will be happy to assist you. If you don't see either of our names, you can message all panelists and we'll be able to help you from there. Maggie Schmidt joined the Victim Rights Law Center in 2019 as a staff attorney. Maggie works out of the VRLC's New Bedford office and has worked with survivors throughout the Commonwealth on Title IX issues, along with representing survivors in safety and privacy matters. Ruth Vaughan joined the VRLC in 2017. She represents victims of sexual assault and education matters in K-12 and campus settings. She also provides training and technical assistance to institutions of higher education, participating in the Office on Violence Against Women Campus Grant Program. Thank you, Maggie and Ruth, for being here today, and I'll pass it over to you guys now.
Great. Thank you so much, Charlotte, and thank you to MOVA for inviting us to talk about this really interesting and important topic about privacy at the intersections of Title IX and criminal cases. And as Charlotte mentioned, myself and Ruth will be your presenters today. Ruth will primarily be off screen answering your questions in the chat function, and she will resurface when we go through some hypotheticals and open up for a bigger Q&A. So I'm really glad to have her here. As mentioned, we are both staff attorneys at the Victim Rights Law Center. The Victim Rights Law Center is the first legal nonprofit in the country to focus on the civil legal needs of survivors of sexual assault and rape. And we work both in Massachusetts and we have an Oregon office. And in our office, we provide a number of legal representation in different areas for survivors of sexual assault and rape, including education, housing, immigration, privacy, safety, employment, and Dwyer matters in criminal cases. And we find that privacy is a key component to our representation in all these areas of law. And so we're really excited. I'm excited to speak to you about talking about privacy, especially in Title IX, as well as the criminal justice process. So before we get going, we wanted to quickly go over what the objective of today's webinar is. So the goal today is to identify and discuss privacy concerns for students in a Title IX grievance process and the criminal justice process. And to help us get going, we thought it would be nice to get to know our audience a little better so we can better serve you in going through this topic. So if you could use the chat feature and tell us your name and the type of organization you work for, that would be wonderful. And so I'll give you a few minutes to go ahead and do that.
All right, we have some district attorney's offices represented, sexual assault response unit, DPPC, Clavic attorney at the Children's Law Center of Massachusetts, the VRLC, DA's office, grants data manager at MOVA, Norfolk District Attorney's Office. This is great. Title IX offices, victim advocates, EMC Community Violence Response Team. This is great. Thank you for responding, everybody.
Yeah, and to help Ruth and I understand a little more, we wanted to launch a quick poll where we're going to ask you about your general knowledge of Title IX. So the question that will be popping up in your poll is, how familiar are you with Title IX? A, this is all new to me. B, I know a little about Title IX. C, I know a lot on this issue, but have not advised any students. D, I have been an advisor in 1 or 2 cases. Or E, I have advised lots of students through campus disciplinary or grievance processes. All right. So it seems like most of our audience knows a little bit about Title IX, and some of you, this is all new to you. And then we have a couple of people throughout with some knowledge up through having advised a lot of students in the campus process. So thank you again for participating, and this helps us know our audience a bit better. So before we dive into some specifics, let's take a step back and think about sexual assault on college campuses. According to one federal study, approximately 19% of women will be sexually assaulted during their time at college. So approximately 1 in 5 women. And when we think about Massachusetts, Massachusetts has over 100 institutions. So there are a number of survivors that could seek to go through a Title IX process and a criminal case. So before we dive in, let's think about what that means. You can think about a student attending a school in, let's say, Worcester County. They're sexually assaulted on campus and they're trying to figure out what to do next. They go to a variety of supports, learn that they can go through a Title IX process where the school will investigate and adjudicate a case. They also learn that they can report to the local district attorney's office or the local police and have the district attorney's office prosecute that case. But then they're also seeking other services to support their recovery. So maybe they're talking to an advocate, they're talking to a mental health provider, and they're going through all of these systems and they're trying to explain what has occurred and reach their various goals. And with that, there are some services that have privilege and confidentiality and some that don't. And so what we're going to do is we're going to dive in thinking about privilege, thinking about Title IX and the criminal justice process. So why are we focusing on Title IX, the criminal justice process? As I mentioned earlier, there are a variety of different areas or ways that survivors can seek justice. There's other areas of law to seek justice, but why these two? Title IX and the criminal justice process are often ones that students are very familiar with. And they're processes that a student can go through at the same time or separately. So what this means is at different times they can pursue these different options or try to go through them together. But they are very different processes, even though they seem very similar. Both of these processes seek to adjudicate a violation, whether of a policy or the criminal or a criminal statute. So some of the key differences. The first key difference is Title IX is concerned about equal access to education. So when looking at a violation under Title IX, a school is looking at whether access to education has been prohibited. Versus the criminal justice process is concerned with whether there's been a violation of a criminal statute. And specifically, we'll be talking about the criminal statutes in Massachusetts. A key difference is the standard of evidence. As I'll go through a little later, Title IX allows the burden of proof of either preponderance of the evidence or clear and convincing, while the criminal justice process uses beyond a reasonable doubt. With these two processes, it's important that survivors, especially student survivors, understand that these are two different processes, what remedies they can offer, and how they intersect. And the reason that this is so important is so that a survivor can make informed decisions to best reach their goals, whether it's through these processes or other processes. So we're first going to start off looking at the Title IX process and how are victims' privacy interests at risk in the Title IX grievance process. So as we learned in our poll, some people are new to Title IX, so let's take a step back and look at Title IX. So what is Title IX? Title IX is a federal civil rights law that prohibits sex-based discrimination in educational settings. What this means is institutions that receive federal funding must respond to sex discrimination. Sex discrimination is defined as sexual harassment, which includes sexual assault as a form of this prohibited discrimination. It is important to note that Title IX does apply to public K-12 schools. However, Ruth and I are going to focus on the college setting as there are some differences in how, in particular, the new regulations with hearings work. But do keep in mind that this is both for colleges or institutions of higher education, as well as public K-12 schools. Title IX also uses a different definition of sexual harassment that we find in our criminal justice laws. So what is sexual harassment? Under the current regulations, sexual harassment includes sexual assault, dating violence, domestic violence, stalking, quid pro quo sexual harassment, or unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensive that it denies a person equal access or equal education access or access to educational programs. Each of these are defined within the regulations, and they are different than the definitions that we find in our Massachusetts criminal laws. So specifically, if we look at the definition of sexual assault, it talks about how it is a forcible or non-forcible sexual offense as defined under the FBI crime statutes. And what that is typically a non-consensual sexual intercourse that occurs on campus. Quid pro quo sexual harassment is an instance where there's a situation where someone's submitting to someone's advances, either implicitly or explicitly, is connected to their grades or an educational benefit or aid with the educational facility. One of the things that is very important to understand is these are the only types of violation that require a school to have a response under Title IX. These are not discretionary in how they are defined, and all these are defined within the regulations and other federal laws. So another way also to look at these is these are going to be defined in every institution's policies related to Title IX. And so if you have further questions about those definitions, we're happy to answer them. But if you're working with a student, a great place to start looking at these definitions is going to be in the university's Title IX policy. So we know that with sexual harassment, schools have to respond. So what does that response look like? And I'm going to take a little bit of time to shift into talking about what is required of this response. Many of you are probably aware that as of August 14th of 2020, there were some changes that came to our Title IX processes. There were some new rules that were promulgated or created under the Trump administration that specified specific grievance processes that are required by institutions to implement when there's a complaint of sexual harassment. One of the large things that many people are aware of is this process for campuses specifically is that it must include a live hearing with cross-examination. So what does that mean? That means a hearing held where everyone's present, where questions can be asked, and cross-examination means that the party's advisor asks questions of the witnesses and the parties. And what this means is that individual students aren't allowed to represent themselves in their hearing. Also, the standard of evidence was previously preponderance of the evidence, and it allows now for preponderance of the evidence or clear and convincing. So what are those evidence standards? Is they're different than our criminal justice beyond a reasonable doubt? Preponderance of the evidence is more likely than not that a violation occurred, or what I typically refer to as 50% and a feather. And clear and convincing, on the other hand, means that the information presented in support of this alleged violation is substantially more likely to be true than untrue, and it's something greater than 50%. Another thing to keep in mind, these regulations and their requirements are not retroactive. So what does that mean for students? For students, that means any allegation of sexual harassment that occurred prior to August 14th of 2020 would not fall under these policies. And universities have policies that were previously in effect that would address these allegations. One thing to keep in mind is prior to August 14th of 2020 was that universities had a lot more flexibility in what their grievance process looked like. And specifically, there wasn't a requirement for a live hearing, and some institutions didn't even have a hearing process. If working with a student from an allegation that occurred prior to August 14th, going back to the university's policy beforehand is going to be the goalpost and the guiding post. But some of these privacy considerations we're talking about will still be worth considering in those processes. So I'm going to take a little bit of time to discuss some terms as well as a little more specifics of what this process looks like. Let's talk terminology first, as many of us are familiar with the criminal justice terms, but Title IX doesn't use the same terms. So the victim survivor or the victim witness, as we refer to in Massachusetts, would be referred to as the complainant or the reporting party. Our defendant or perpetrator is referred to as the respondent or the reporting party. In Title IX, there's a difference between a report and a formal complaint. A report is when an administrator is notified in an institution that sexual harassment has occurred, but that doesn't necessarily mean that an investigation is triggered. What starts the investigative process and the grievance process is a formal complaint. And a formal complaint is a written document outlining the reporting party's experience that happened on campus. And it's this particular type of complaint that initiates the full process. One of the biggest discrepancies and misunderstandings about Title IX is what actually happens at the end. In Title IX, we are not having a guilty verdict. In Title IX, we're having an outcome or findings, and we're looking at whether or not an individual is responsible or not responsible for violating the university's policy. So as we walk through some of these examples, we'll be using the term responsible or not responsible, as that's what universities used. In addition, there's another key player that Ruth and I will mention, which is an advisor, and that's somebody who can work with the complainant or the respondent throughout the grievance process. So with this terminology, what does a Title IX grievance process look like? And this is an overview of what the grievance processes look like across universities. The key thing to remember is every university is required to publish their policy, and that policy is going to detail specifically what's going to happen, how to report, and going through the process. So if you're ever working with a student, looking at that policy is going to be your best roadmap for serving that survivor and understanding where they are in the process. So as I mentioned at the beginning, a formal written complaint describing the experience of the complainant will start an investigation once this has been reviewed by the Title IX office. With the investigation, there's an investigator, and that person's job is to conduct the investigation and collect evidence. So what does that actually look like? This means the investigator meets with the complainant one or more times to talk about their experience. So asking questions, asking if there's any documentary evidence. They'll talk to the respondent if they're wanting to participate, and any witnesses that they discover. And the investigator collects all of the information that they can to try to understand the allegation that's been brought forward. Once this has been completed, there's this period where the parties, and if they have an advisor, get to review the information that has been collected. This is called the evidence review and the report review. At the evidence review, this is where the investigator provides to the parties things such as outlines of witness interviews or summaries of witness interviews, any documentary evidence, so anything like text messages or videos or photos that were provided from that night, or any other documents provided either by the parties or the witnesses. The parties then get to respond to this, and then the investigator takes the information and drafts a report based off the information they deem relevant. And we'll be talking a little more about this idea of relevance in Title IX in the coming slides, because I will foreshadow it does look a little different than our criminal justice process. Once that report is made, the parties are then able to review the report and see what information the investigator found relevant. Then the process moves to a new set of people, the people who run the hearing panel, which are referred to as decision makers. And these are the people that are going to conduct the panel, as well as ask questions and find the information to understand whether or not a violation of the policy occurred. So they'll hold the hearing, have the parties there, have advisors there, and hold that hearing. A crucial piece to understand about this hearing is that the hearing is actually recorded. So for example, in our current state of affairs, if there's a hearing panel and it's on Zoom, it will be recorded and saved along with the report and any materials. That hearing panel then takes all of the information that they collected from the hearing panel and what is relevant, and they write findings of fact and an outcome in the case. This outcome is then sent in writing to both parties, and the parties are then given an opportunity to appeal. So with this process, we kind of have this longer process with a variety of different people looking at different types of evidence. So in thinking about that, what evidence is going to be used in a Title IX process? And the big thing to keep in mind going forward is Title IX evidence is broader than what is typically used in criminal justice processes. So starting off, who provides the evidence or who collects the evidence? The parties and their witnesses during the investigation are the people who provide the evidence. So when a complainant is meeting with the investigator, they're answering questions and providing statements, but they're also able to provide any photographs they have, any videos they have, any documents they want to share. Witnesses can also share these documents as well. So this is a little different than a police officer going out and investigating and potentially having to access videos in other ways. It's all brought by the parties. And that's an important thing to keep in mind because those individuals have the choice to provide that information. What types of evidence are allowed in a case or allowed to be brought forward? The big difference in Title IX is that the rules of evidence do not apply. There is this general acceptance of circumstantial and hearsay evidence and it's a big part of the Title IX process. So what's an example of that? If a complainant, let's say Jane, has a friend Anne who she spoke to after the assault, Jane can ask that Anne speak to the investigator. Anne can speak to the investigator about this is what Anne told me happened on the night of the assault, and this is what I've noticed about Jane after the assault. That is evidence that would be taken into Title IX and considered and relied upon. One of the structures that is in place through the regulations is rape shield protections. These are built in with very specific exceptions. But this does open up the question of what is meant by relevant evidence. Evidence has to be relevant to be relied upon, but what is relevance? Unfortunately, the Title IX regulations don't define relevance. So what this means is there's a lot of different pieces of information that could be brought forward and used by both the investigator and the decision makers. So where do confidential and privileged records start to come into this? With evidence in Title IX, if a party wants to provide privileged or confidential records, there's a requirement that there be written consent of the party providing that documentation. So if somebody wants to provide a mental health evaluation, they have to sign a consent form for that. Parties can also answer questions related to privileged and confidential information. information. And we'll talk a little bit more about that as we move along. The key thing in evidence as well to Title IX, any evidence submitted is going to be shared with the other party. So there's no ability to say as a complainant, I want to provide this to the investigator, but I don't want the respondent to see it. If it's provided to the investigator, it will be provided to the respondent. And this is something that happens throughout the Title IX grievance process. And this is why we're so concerned about privacy in Title IX. As we've talked about, there's a number of opportunities where privileged or confidential information comes out. And there's a number of spaces where students might feel like it's necessary to. And so ultimately, we want to take a look and see what information can be provided or should be, and really looking at that in light of the relevant standard. So, and I want to reiterate this again, because it's very different for those who work in our civil and criminal justice system, is that there are very few limitations on the evidence that can be provided in Title IX. It is very broad, and it means that a lot of information is included in these investigative reports and hearing panels that we might not see in other types of cases. So, knowing how broad the evidence can be, what are some of the confidential materials that a student may decide that they want to bring into a case? So as I mentioned earlier, I referred to mental health records. There are a number of other privileged records that a student might want to bring forward to try to show that sexual harassment, specifically a sexual assault, occurred, or the impacts after. And some of these records we'll hear about are often mental health or counseling records or other therapy records, medical records, both those from on-campus health services. So students often use their student health services. So records from those providers, as well as off-campus medical facilities, and advocate records, both those on-campus resources and our off-campus resources. And beyond providing these documents, I also want you to keep in mind that students can provide information about these, not just the documents themselves. And while these documents have protections as privileged or confidential materials, there are also a number of records out there that contain privileged and confidential information. So they refer to other information. And these include education, employment records, or telephone records. So why do I bring these up? I bring these up because often these records might include names or information about privileged and confidential resources. So for example, I want to provide some telephone records because I think it shows how often a respondent called a complainant. I want to take a look at those telephone records to see if there are any phone numbers of mental health providers or advocates that they're using, so that if that client wants to go and speak to and report to the police, that information isn't there. Also, with education and employment records, sometimes there's referrals to providers, and those are worth taking a look at. And it's really important to take a look at which pieces, if those records are provided, and what information is shown in there. So anybody working with a student should take a look at those records and really see what information is there, because sometimes we overlook those small references to other privileged and confidential materials. So I've talked a little bit about the process, about evidence, how we get evidence into the process, but what happens when a Title IX process is done? Why are we so concerned about sharing these privileged and confidential materials if once this process is done, can it be accessed? In fact, materials from a Title IX investigation, both those written documents as well as things like the recording from the hearing panel, can be accessed. So who can access those materials? So first we need to consider that these materials, because they're done through an institution of higher education, are covered by the Family Education Rights and Privacy Act, or FERPA. So what this means is both parties, both the complainant and the respondent in the case, have the ability to request this record because it's part of both of their educational records. Additionally, these records can be subpoenaed compliant with those rules. So there can be a request to the school to provide these records. Oftentimes, students, complainants, response, and witness will be aware that Title IX policies or student codes of conduct may include confidentiality provisions or duties not to share information from the investigation, but that doesn't prevent these records from being used in future litigation, whether civil or criminal. And so what does that specifically mean in the criminal context? In the criminal context, this means, for example, the respondent, who may now be a defendant, can request a copy of all this information. So a copy of the report, the evidence that was relied upon, and the hearing recording. Additionally, district attorney's offices can request these materials to see what investigation was had, what statements were made, and other information that was brought about. And this is something we see very often and something that we're talking to clients about. So for example, if I have a student who is going through a Title IX process, I might get a call one day saying the district attorney's office is trying to get the Title IX investigative report. I don't understand why. I didn't know that they could get that. Or down the road, we'll have completed a Title IX process. There's a criminal case going on, and suddenly there's a request under Rule 17 for some records, and we don't understand why. And it's because it was referred to in the Title IX report. So keeping this in mind is really why we want to talk about privacy and how they intersect. So thinking about Title IX and how this information can be accessed, how are victims' privacy interests potentially at risk in a criminal case? How do we get from speaking about my mental health provider in Title IX to records coming in a criminal case? So in Massachusetts, that comes from Rule 17, or what we refer to as Dwyer motions. So a quick overview of Rule 17. Rule 17 is a pretrial motion to obtain records of a third party. And these are records or documents or other tangible pieces of evidence. And this can include the victim witnesses or that Title IX complainant's records. Records that are covered by a statutory privilege or records that may contain a statutory privilege or confidential information may be sought through this Rule 17 structure. And if they are privileged or confidential material records, or they may contain that information, they go under our Dwyer protocol, which is a protocol that was announced in Massachusetts under a case called Commonwealth v. Dwyer. And what do you need for a Dwyer motion? How do we get from requesting records? What do we need? In Massachusetts, Commonwealth v. Dwyer does outline a legal standard that, for example, a defense needs to meet to show that they need these records. But there's other key information that the defense would require. And this includes the name and address of the record holder. So name and address of a record holder can be the name of a provider or the name of a practice group. So for example, like a specific name of a hospital that somebody went to or a place that somebody worked, even if it's not an individual provider. So the name and address of who holds the records, the name of the third party subject. So the person that the records are about. So in the context that we've been speaking about, that's the victim witness, so the complainant. So saying Jane's therapy records from this location. Additionally, the motion has to include a description as precisely as possible of the records. So what does this functionally mean? This functionally means a description about what the records are and what's included. So defense knows that Jane is seeing a therapist through a UMass medical therapy group. They are aware that they are seeing this therapist because in the Title IX report disclosed that right after the assault, Jane went to the therapist, described the sexual assault, and has been working with therapists to discuss their mental health challenges. And so we know that there are records that exist that talk about the sexual assault. So that's kind of an example of the information that they need and where you can see a connection to getting information from a Title IX report. What is really important to know about Dwyer motions is that Dwyer motions require notice to the victim that the records are being sought. So what this means is the victim witness or other third parties would be informed that this record is being sought and provide the motion. Victims at this point have the ability to have their own attorney appear at the scheduled hearing and assert their view and argue their position about whether or not these records should be disclosed. And so that's an opportunity for the victim to have their voice separately heard. And it's very crucial, especially with these privileged and confidential records. And a plug here that our VRLC attorneys represent survivors in these Dwyer proceedings. So we've talked about Title IX and we've talked about the criminal process. So how do you discuss with a student survivor the intersections of Title IX and the criminal justice process, and how to make some decisions on whether or not to give records or present information about somebody that might hold a privilege? So first things first, having a conversation with the student about their goals is going to help discuss privacy, confidentiality, and what the next best steps are. Why do I say to talk about goals? I say to talk about goals because oftentimes there's one process or one thing that the survivor is particularly focused on. So the survivor might be focused on, I really want this respondent off campus and I want to achieve that goal no matter what. Or I don't know about these two processes, but I just want to make sure my privacy is protected because I don't want this individual knowing any more about me than they already know. So that helps facilitate a discussion about how do we use privileged or confidential records or avoid using them at all. So the very first thing is, when we talked about the definition of Title IX, is there's an impact on educational access. So in Title IX proceedings, either the investigator or the hearing panel will ask the complainant, what was the effect or what was your impact of the sexual assault that we're looking into? And so what this means is that a survivor is going to answer that question. And there's a variety of ways that sexual assault impacts a survivor's life. This can be everything from academic performance, ability to attend class, social connections, attending work, as well as mental and physical health implications. So we want to talk to the student about how are we going to answer that question in a way that you feel comfortable, but also, if you want to protect your privacy, doesn't list all the names of the providers that you're seeing and are providing you support. And this is really important because, as we went over, there's a number of stages where this question could come up, and being comfortable speaking about the impact without inadvertently providing information that could be used later is beneficial. And I actually have my students practice answering this question because it can be really odd to say, I'm having a lot of mental health concerns without going and saying a diagnosis. And so talking through, what does answering this question look like? Because in every Title IX case, you will answer a question on impact. Additionally, there should be a discussion about the implications of consenting to the use of privileged or confidential records. So it's one thing to talk to a student about answering questions. So answering questions about impact or answering questions that are related to it. But what if your student survivor wants to provide a mental health evaluation or a medical record that shows that there was testing for a sexually transmitted disease? These are ones we commonly see. What happens if I provide that written consent for the Title IX investigation to use this and the decision makers to rely on it? And what is crucial to have students understand is that once the use of this record is put out there and that privilege and confidentiality is waived, it is difficult to get that information back. Just like I said, the respondent is going to see this information in the investigative report and in the hearing panel, and it can be difficult to raise this privilege down the road. Additionally, having that conversation upfront with a student survivor about, if we provide this record, here's what this record says. You've also expressed potentially wanting to go through the criminal justice process, or there is a criminal case going on. There's the potential that a defense attorney will be able to access this and use it as information to get more of your records. So having that very clear discussion about those records and those implications. And I want to talk about some more specific examples of what we particularly look at when talking with students. There's a risk when talking about our experience about disclosing names of providers, locations of medical services and advocacy services and diagnoses. And as I talked about when we talked about what is needed in Dwyer, that provides a lot of information. And that's the information that can be used as a basis of that motion. So what are some examples? Maybe there's a student answering a question that says, I was diagnosed with PTSD and have been seeing a therapist at UMass Medical. So there's now that diagnosis information and a location of a provider. And that's one that's pretty common with this idea of impact. What was the impact on my education? Another thing that comes up that people have to start to think about, especially with this live hearing component, is at a hearing, a complainant could be asked a question that they know the answer only from privileged or confidential materials. So for example, something from a medical record. And a question that I can think of is, how do you know that the injuries you suffered that day were from the respondent and not from the fall earlier that night? So maybe the complainant knows that because they read something in the medical report and they need to know that they should raise that privilege at the hearing. So that's another example of the potential risk of saying that that information's in that document and that document is covered by privilege. The other thing with all of these risks, I've talked about all of these concerns with privilege and confidentiality. In Title IX, students are able to raise this privilege. So they're able to not sign a waiver to provide the documentation, as well as say, I'm not going to answer this question due to a privilege. And those are really important to keep in mind as they go through the Title IX process, where lots of evidence is relevant and lots of different pieces can come in. So we've talked a lot about privacy. So how do we functionally help students go through this Title IX process and understand privilege and confidentiality while explaining a traumatic event over and over, hoping to get an outcome? As I mentioned earlier, the complainant and the respondent, but particularly the complainants, have a right to an advisor of their choosing to assist them in the grievance process. So an advisor of their choosing means it can be an attorney or anybody that they'd like to have support them through. And the advisor plays a critical role. And so why does that critical role happen with an advisor? An advisor can be involved at every step of that flow chart we went over. So they can be involved with writing the complaint. They can be involved with the investigative meetings. So sitting in the investigative meetings with the complainant, as well as reviewing evidence, determining what evidence to submit, and being at the hearing, not only for cross, but to answer questions or help the student navigate the hearing panel. And so this person can help as these privilege and confidentiality issues come up, talking to them about the benefits, the potential cons, any waivers, and how to navigate this situation that can be very difficult for some survivors. What is a key thing to know is that simply because somebody acts as an advisor in a Title IX proceeding does not in and of itself make them confidential. So if somebody has an attorney as their advisor, attorney-client privilege would attach. But if a student chooses to have maybe a faculty advisor, there isn't a privilege there. And so simply because they're advisor there doesn't mean that those communications are protected. And because of this, we encourage that advocates not serve as advisors because of some of these privacy concerns. And we encourage, especially in Massachusetts, to reach out to the VRLC, where our education attorneys can serve in this advisor role. But even if not serving in an advisor role, there's a number of ways that students can be supported by advocates and addressing privacy. So what are some of those examples? So advocates can take a look at your record keeping policy, see how communications are being recorded. Also, helping students to write letters to services and medical providers about not disclosing private records without those consent forms or without the explicit permission of the complainant. And also working with schools to protect privacy as much as possible. So encouraging schools to explain these privacy concerns and really ensuring that students are aware that they have the ability to protect their privacy and that it's well explained to students. So we've talked a lot about all of these different types of records that can come in and different things to think about with students. So I'm going to have Ruth help me a bit, and we wanted to run through a couple of hypotheticals and use the chat to kind of talk through some of these and how we see them.
Thanks, Maggie. And thanks for those of you who have added some questions in the chat. I can still see the chat, so feel free to keep using it. We're going to run through 2 hypotheticals, and I would love to see some of your responses as we go in the chat, and we can talk through them. If you have any questions, again, please feel free to raise them. So the first hypothetical is about Skylar. Skylar is preparing to meet with the investigator in her Title IX case about a sexual assault she experienced on campus. Prior to the assault, Skylar was diagnosed as bipolar. The assault has affected her mood significantly. Skylar also reported the sexual assault to law enforcement, and it is currently being investigated. Skylar is preparing to describe the impacts of the assault. What privacy concerns do you have in preparing to answer the question about impact? And like Maggie said, that I will just reiterate, is impact is pretty much guaranteed to be asked. How is this affecting your access to education? How is this affecting you? What is the impact of this experience? And something that we also talked about, obviously, she's reported to both school and law enforcement. So those processes can be pursued concurrently. There was a question about that in the chat earlier. So these are simultaneous investigations that are happening. And again, like Maggie said, Title IX processes tend to move a little bit quicker than criminal justice processes. It's not a hard and fast rule that they absolutely will, but typically that's what happens. And so just thinking about that, whatever comes out in the Title IX investigation is likely going to, come out in a criminal justice process later. So what privacy concerns do you have? If you could use the chat, there are no wrong answers, just an opportunity for us to dig a little bit deeper and to kind of discuss some of the things that Maggie went over. We have a diagnosis. So we have a bipolar diagnosis, and ostensibly someone made that diagnosis. And so that might be an area that you would, exactly, yeah, Melanie, thank you. Diagnosis, who diagnosed, is definitely something you want to talk to Skylar about, making sure that you give all of the information to Skylar about what could possibly happen with that information if she decides to disclose that in the Title IX investigation. One of the things that, I'm sure all of us who work with victims take a very victim-centered approach to our work. And so I think our job in these processes is really to make sure that we're conveying all of the information so that the client, the survivor, can make an informed decision. And we've absolutely had situations where we've said, look, you can, if you really feel strongly that you want to talk about this diagnosis and who diagnosed, you want to give that information in the Title IX investigation, because it is really important to you to make sure that the respondent hears that and at least is confronted with it at this particular stage, then that's fine. Here are the implications of that. And we've had situations where the client has said, absolutely, I feel very strongly about this. And that's their decision, as long as they are empowered with the information. I think that's really the most important thing that we can do as advocates and as advisors. Yes, we have who she might have sought support from related to the impacts. Yes, absolutely. Advocates, therapists, healthcare, university staff, these are all great suggestions to talk to her about the privacy concerns surrounding the support of that, the effect of the mood, and how things have transpired since the assault. Great answers. Anybody else have some thoughts? I think that's great. Maggie, did you want to add anything before we go on to the second hypothetical?
Yeah, I think things to think about with students when they talk about their mood, they might talk about what they have done to help with their mood. So one of the things with mental health conditions is sometimes they'll say, and then I was put on X medication. So also thinking about when talking about it, are there types of medication or anything else that could be described that could be used? So I always think of if they want to talk about their medication. So I think that's another key piece to take a look at as well.
Yes, and we have how about who she brings with as an advisor and support person to the meeting with the investigator. Yeah, so I mean, certainly if Skylar is considering, asking a question about whether they can bring, a counselor to a meeting, that is absolutely something that we would discuss with them. We've actually seen counselors, serve as the advisor in certain processes. And like Maggie said, that is something that we usually raise concerns about, because the role that the confidentiality that a counselor has with the student will likely not be transferred to that advisor role. And so we always raise the possibility that if there is ever an attempt to gain access to those counseling records, it would be very difficult for the counselor to show that in this particular conversation, 5 minutes, they talked about, what they would normally talk about in their counseling relationship. But then for these 30 minutes, they only talked about what they would talk about in their advising relationship. Those things are often very intertwined. And so we would be concerned about the piercing of that confidential relationship. And so, yes, we would absolutely talk to Skylar about maybe really just preserving that counseling relationship, and making sure that that is something that cannot be pierced later on. That's a great suggestion. All right, let's go on to the second hypothetical.
Let's go on to
Okay, this is a hypothetical about D. D was sexually assaulted at an on-campus party. D went immediately to Beth Israel Hospital for a SANE exam. D then reported to Title IX and isn't sure whether they want to report to law enforcement. But that's a possibility after the Title IX outcome. The investigator in the Title IX case is asking if D wants to submit the SANE report to support their case. What would you want to discuss with D before they decide? So here we have obviously some medical records that we are, considering, and anything that's transpired since, the SANE exam, anything related to the health or medical needs of the survivor, and thinking about how these processes are likely, if they're going to be both pursued, they're going to be pursued subsequently to each other. So the Title IX case will likely wrap up before a criminal justice case has begun. So what would you want to discuss with D before they decide whether to submit these, to submit their SANE exam, then the records from their SANE exam? And these are all things that we've encountered repeatedly in our work at the VRLC. I think survivors are often in this position of being asked by investigators if they want to submit records to support their case. And it feels a little bit like, it's kind of a lose-lose situation. If I submit these records, there might be stuff in there I don't feel comfortable with the respondent having access to. But if I don't submit these records, are they going to think that I'm trying to hide something. And so this is a very common situation and in a conversation that we have with survivors that definitely needs some attention and careful thought about how you have that conversation. Oftentimes there are providers, there's diagnoses discussed in those medical records, like Maggie mentioned earlier, that you would definitely want to talk to the survivor about, what did you disclose? What could be in there that we want to kind of think through before making the decision to submit them to the investigator. And then thinking about how, if you submit them, how do you make sure that can they be redacted? Can there be some way to prevent all of the information from being provided and used later on? Anybody have any thoughts about what else they would want to discuss with D before they decide? We have a very shy audience. You won't ask me to unmute. It won't. Yes, thanks, Stephanie. What are Dee's priorities? What does Dee think the SANE report will show in their case? Absolutely. What are Dee's priorities? Do we want to really help Dee in the Title IX process and get Dee to a good outcome in the Title IX process, kind of irrespective of what might happen if and when they report to law enforcement? They might say, law enforcement, going through a criminal justice process is not a priority for me right now. And I don't think I'm not sure it ever will be, but I know that Title IX, I know that I want to prioritize this process. And if, getting D to that point means providing some of those records and they're willing to do that, that might be something that you discuss and kind of lay out the options for. Absolutely. Anyone else?
I know one of the things with medical records is, especially now with electronic medical record systems, all of our records are often tied together. So if you see, say you're with Partners or Brigham, all of your records are going to be tied together. So if you get a discharge notice, so the piece of paper that the nurse hands you when you leave, it's going to have all of your diagnoses and any medications or any refills. It's not just going to have what you went in for. So looking at the SANE record, what else is included in there, especially with our highly technology world where it's lovely to have all of our medical records together, but from a privacy perspective, what other information is there? So that's really something that I'd want to think about, because even though this is a privileged record, does this have other privileged or confidential information in there? And also, are there any referrals to places, including other mental health providers, other doctors? So what is actually contained in that document? And one of the things that is sometimes helpful with students is getting a copy of the records and then looking through it with the student and walking through what information is actually there. Because a lot of people don't actually know what's in a record. And so it's helpful to go through and look at that record and make a decision that way.
Absolutely. We have a question from one of the participants. Should they even tell the investigator they had a SANE exam? If the investigator mentions it in the investigative report, does it become something that could be requested by the responding party? Great question. Maggie, do you want to answer? Do you want me to take a stab at it?
I can chat a bit about. So typically there is a question of whether they sought medical treatment. And as we talked about earlier, it's up to the party who holds the privilege to the record to sign that written consent form. So if they don't provide it, the respondent could potentially raise, but I want to see this document. But the school is not going to force a student to waive their confidentiality or privilege if they don't want to. So they could try to request it, but the school will say, unfortunately, they have not signed this written consent form for these documents, and so we can't provide it to you. And this is something we've also seen on appeals. A respondent will bring up, well, they mentioned these records, but they didn't provide them, and they must be pertinent to the case. So it's something that our clients often mention, but then they can decide not to provide those documents. And the Title IX regulations do have some support there to ensure that they're not forced to provide them over. Ruth, I wasn't sure if there's anything else with that.
No, I think that's perfect. I think we take issue with a lot of what was contained in the Title IX regulations that has shifted so much in the last year. And one of the things that I think is a benefit is requiring this sort of written consent to for investigators to use confidential and privileged documents in the course of the investigation. In the past, prior to August of 2020, there was not that requirement. And I think a lot of students that we worked with, even before they would get to us, sometimes they had just turned over records because they thought it was going to help their case, and didn't have the benefit of really kind of thoughtfully considering some of the privacy implications there. And so, yes, I think Maggie is absolutely right. They can't be accessed by the responding party if they have not consented to having them used in the Title IX process. That's going to be different in a criminal justice process, but in a Title IX process, yes, they are. That's the way Maggie set it up is right on. If the records are sought via Rule 17 in regards to a criminal case, can they be provided on appeal to a Title IX claim? So if records are sought in a Dwyer, can they be provided on appeal to a Title IX claim? You mean, and sorry, just to clarify, Caitlin, are you saying can the Dwyer motion be provided on appeal in a Title IX process? Oh, okay. I think so the appeals in Title IX, at least, I mean, I think it depends on the grounds of what a school allows for appeals to be based on. There are a few grounds that are required by the regulations, but schools are allowed to go beyond that and allow for appeals beyond that. Some, I don't know if you could make the argument that that is new evidence, because it would obviously be related to evidence that was already provided in the Title IX investigation and outcome. There may be a way to use it, but I'm not sure. I mean, it doesn't strike me as that would necessarily get, I'm not sure if it would get you that far unless you're trying to show that they are trying to access those records that wouldn't be otherwise accessed in a Title IX case. Maggie, anything to add to that?
I don't think so. There's some additional thoughts there. If there are records that are that the judge determines to pierce the privilege, and there are records that order turnover, there is a process by which they're protected in the court. So it does become a little more difficult to then take the records and go use them. So I think there's a couple intersecting pieces there, but I think you're right. I don't think a Dwyer motion in and of itself would do anything. I've seen a number of appeals where they say, they refer to this person but didn't provide the document, and that doesn't seem to gain traction with an appeal.
That's a good question. I like the way you're thinking about these processes impacting each other. That's exactly what we're trying to get you all to think about.
And especially because where there is a criminal investigation or criminal case, oftentimes the criminal defense attorney will come in and be also in the Title IX process to understand what information is going on. So it's a great way to think about it.
Are there any other questions that are coming up? Sorry, Maggie, go ahead.
I was just going to say, we can actually move towards more general questions, since that seems to be where the audience would like to go. But before we jump into questions, we just wanted to note that our VRLC attorneys represent students in both Title IX proceedings and in Dwyer hearings. So we provide our intake information that student survivors can call and request our support, as well as our information. But I think it's a good time to open the floor to general questions you have, either about the process I discussed, or some of these intersections, or even some of what you're seeing now. I think especially in this weirdly digital world, things have gone in different ways. And so maybe you on the ground have seen things play out, or just have questions as we're starting to see these new Title IX regulations play out.
And you certainly, this is not the only opportunity to reach out and ask questions. We are available if you want to follow up at any point if things come up later. Okay, we have a question from Stephanie Holt. How do you prepare a student for cross-examination?
Question, Stephanie. And I think this brings in a quick little detail about cross-examination in Title IX. If you've seen a courtroom drama or been to court, as I think a number of our attendees have been, in cross-examination in a courtroom, a question is asked and then the witness responds unless there's an objection and the judge determines we're not answering that question. In Title IX, things are a little different. If the panel is asking that question, a student immediately responds. With cross-examination, or where the advisor is asking a question of a party or witness. So say I'm the compliance advisor and I have witness A. There's this process of relevance. So you actually ask a question, the panel will generally nod and shake their head if it's relevant, and then they'll answer the question. So when preparing our students and our complainants for cross, we'll run through kind of some examples of what questions look like and how to be prepared if there's a question that does invoke privilege, and get them used to this slightly odd way of answering questions where they'll be asked a question, there will be this awkward silence. I also talk through my students about taking a deep breath when a question is asked, especially if it's the respondent's advisor. It's going to be very intimidating. Taking a deep breath, repeating the question in their head, and then answering the question. This is also a good time in preparing for cross. So when we're going through questions, of signaling to the student if there's a question that might invoke privilege and how to ask to speak with your advisor. One of the other things with cross-examination that's unique in Title IX is the student can ask to speak to their advisor at any point. So if there's a question that they want to talk to their advisor before answering, then ask to do so. So that's another way to help prep, is not only working through how to answer the questions, but also reminding them that if there's a question that they're unsure about, or if there's privilege, or if there's a concern, to say, may I speak to my advisor? And then in the world of Zoom, they'll be put off into a breakout room to speak with their advisor. Ruth, I didn't know if you have other preparation skills that you use with your clients.
I think I would just add two things. The first is, even before the Title IX regulations required a cross-examination, one of the things that I think all of us at the VRLC would do with our clients is vigorously prepare them for interviews with the investigators. And that even, is kind of like preparing for cross, not because investigators are trying to, like attack them, but I think investigators are asking hard questions. They're testing credibility. They're assessing, demeanor. They are, asking questions in different ways to get at veracity. And so we spend a lot of time preparing clients for investigative meetings or interviews. They can be called interchangeably. And so I think that is another, reason why advisors are so important to have from the outset, because really working with a student during the investigation and preparing them for that robust, evidence collection and essentially, providing testimony is such important groundwork for that hearing. And by the time they get to a hearing, they're going to be used to handling questions. It's going to be in a different format for sure. And there's going to be a different dynamic as decision makers are sort of weighing in and sort of the overseers of the process at that point. But you've still set such important groundwork in the investigation. So that's one thing I would say. And the other thing I would say is, for those of you who may advise survivors through a grievance process, the Title IX regulations do not prohibit. There's nothing in the regulations that say doing a direct exam is not okay. If a policy is silent on it, which a lot of them will be, then I would say, I would ask the Title IX coordinator, whoever you're working with at the school who's overseeing that particular process, ask and say, can I ask my advisee questions before they are crossed? They might say no, but direct examination for those of us who are attorneys or are kind of accustomed to legal contexts, a direct examination gets the client comfortable, allows them to share their narrative in their own words. And I think it kind of gets them into a groove before they start answering cross-examination questions. So that could be something that you try to see if the Title IX coordinator would be amenable to. And it would not be something that would just be for your client. Obviously, this is, Title IX requires equity. And so that's something that if you direct your advisee and the respondent is also is participating, they would be, able to be directly examined by their advisor as well. So it's just something to kind of chew on that I think could be a useful tool in getting your client or your the victim that you're working with kind of comfortable in that space.
And Ruth, I think you bring a good point with the investigation. A lot of the questions the investigator asked are some of the same questions that the decision makers in the hearing panel ask. So if they've been prepared, they've heard those questions before. So it tends to be a lot of information that's gathered multiple times.
Absolutely. That's a good question. There is, we could spend all day talking about Title IX and all of the new, this new landscape that we're in, and strategies and sharing stories from the trenches, and certainly happy to follow up with anybody who has questions afterwards. I don't see any more questions in the chat. So I leave it to you, Maggie, if you want to close out, if you have some concluding remarks, and if there's a question that comes through, I will pipe up and let you know.
Yeah, absolutely. As was provided, and I know will be provided, Ruth and my contact information is there. So feel free to follow up with questions. I am notoriously the person that hangs up the phone and remembers the question that I want to ask. So please feel free to do so. And we just encourage, if you'd like to learn more about the Victim Rights Law Center as a whole, not only the education and Dwyer work that they do, to visit our website. And we really appreciate all of you coming and listening to us and asking such great questions and participating in this webinar. And hopefully this will bring up some new things for you to be thinking about when you're working with student survivors. And then I believe Charlotte wanted to connect back.
Thank you, Maggie and Ruth, for this really informative and important presentation. I learned a lot today. I'm sure everyone else did too. And thank you everyone for attending. So we do have a number of other Victim Rights Month workshops coming up. So I believe Brenna is going to put a link to that in the chat. And then we also do have a feedback form for this workshop. We'll share that in the chat now as well. And then also in a follow-up email, we put the feedback link. We'll share these slides, and we are recording this presentation, so we'll share that as well with you all. So if there's any last minute questions, put them in the chat, but otherwise, thank you all for attending, and thank you, Maggie and Ruth, again. Have a great day, everyone.
Thank you, everybody.
Thank you.